All right, so welcome back, everyone. I hope those listening from home can hear me well. My name is Karina Harry. I'm a postdoctoral researcher at the University of Zurich, where I work on a research project called the Climate Rights and Remedies Project, together with Professor Helen Keller, whom we heard earlier. It's a great pleasure for me to be here today and to chair this panel. Now, we've heard a lot earlier about the merits of Swiss timekeeping. I am Swiss, and therefore I feel obligated to also do that very strictly. I'll apply the same method we heard before, so each speaker will have half an hour. If they don't use their full time, then I will open the floor to some questions. And again, after all the presentations, we'll have time for a more extensive Q&A. Now, our first speaker today is a judge at the European Court of Human Rights, who we're very excited to have with us. His name is Ioannis Ktistakis. I'm very sorry if that was not too good. I will practice that more. He started his mandate as a judge of the European Court of Human Rights in respect of Greece in 2021. He holds a master's degree in political science from the University of Robert Schuman Strasbourg and a master's degree in legal theory from the Catholic University of Brussels, as well as a PhD in law from the University of Athens. He was a member of the Bar Association there, and he litigated many cases before the European Court of Human Rights. He also worked for the Court of Cassation and the Council of State in Greece, as well as working as an expert for several human rights committees within the EU and the Council of Europe. We're very much looking forward to your comments today. I do remind you for the questions that sitting judges of the European Court of Human Rights can't comment on ongoing cases. So please don't ask any questions in that context. Other than that, I, of course, welcome all of your questions and engagement. Thank you. The floor is yours.
Thank you for the invitation. And in the previous panel, in the morning panel, Professor Keller, former colleague of mine in Strasbourg Court, and Natalia Kobylarz discussed the case law of the European Court of Human Rights. I will not repeat it. What I would like to do in my intervention of half an hour is to try to answer the following questions, which relates to the challenges of climate cases, the title of this panel. The question: is there any legal technology available to the international judge to evaluate scientific research that it is the basic evidence in a climate case? Let me start my answer with a personal experience. After all, what I am about to say relates to my past, my experience as a lawyer and academic, not to my present, as many cases are pending before the Court of Strasbourg, as you discussed it already in the morning. In 2010, along with other colleagues, we tried to prove before the Greek courts at the time that a group of 5 major industries built and operate without the necessary infrastructure in a residential area 40 kilometers north of Athens were responsible for a sharp increase in cancer among the residents. Specifically, we tried to prove through epidemiological study that cancer was caused by excessive concentration of chromium-6 in the groundwater and surface water in this area. We succeeded because our epidemiological study was not contradicted by another study. But we failed when we tried to establish the causal link. How could it be proved that the excessive concentration of chromium-6 were due to anthropogenetic factors, intermixed the industries dumping their waste, and not to the rocks in the specific area? The first version was supported by a private research study, while the second, that of the rocks, was supported by a geological study by a recognized state scientific body. The Greek courts were persuaded by the latter study and lost the case. What methodology did they use? None is the answer, because they considered that they could not evaluate studies from other science other than legal one, and prefer the only one carried out by a state body. The case then brought by the National Federation of Human Rights to the European Committee of Social Rights here in Strasbourg in 2013. The committee, for the first time in my knowledge to its case law, proceeded under Article 11 of the Charter and the right to health to a short, brief evaluation of two studies, the two studies that I referred before, by applying the criterion of reasonableness. The exact phrase was, I quote, "The committee considers that when a preliminary scientific evaluation indicates that there are reasonable grounds for concern regarding potentially dangerous effects on human health, the state must take precautionary measures consistent with the high level of protection established by Article 10 of the European Charter." The most important encounter between science and law, to use the title of today's symposium, took place a year later in 2014 in The Hague before the International Court of Justice. Australia filed a case against Japan for Japan's continued implementation of a large-scale whaling program under the second phase of the Japanese Antarctic Research Whale Plan under special permit, in contravention of Japan's obligation under the International Convention for the Regulation of Whaling and its other international obligation related to climate change. This was the phrase of the court. Among the objectives of the Japanese research program were, first, monitoring of the Antarctic ecosystem, and second, modeling competition among whale species and future management objectives. In its judgment of 31 March 2014, the ICJ examined the question of the interpretation and application of the relevant article of the above convention, of which states parties may grant to any of their nationals a special permit authorizing that national to kill, take, and handle whales for the purpose of scientific research. In interpreting this provision, the ICJ held that even if a whaling program includes scientific research, the killing, taking, and treatment of whales under such a program is not covered by a relevant article unless those activities are for the purpose of scientific research. In order to determine this point, and in particular whether the use of lengthened methods in a program is for the purpose of scientific research, the ICJ was consider whether the elements of the design and the implementation of a program are reasonable in relation to its stated scientific objectives. With respect to the application of the relevant article, the ICJ noted that the Japanese plan could broadly be characterized as scientific research. However, it considered that the evidence before it, I repeat, the evidence before it, did not establish that the design and implementation of the program were reasonable in relation to the achievement of its state objectives. The ICJ therefore concluded that Japan had in fact violated some of the provisions invoked and ordered Japan to revoke all existing authorization, permits, and license for the killing, taking, or treatment of whales. The ICJ in this very important case developed its own methodology for the judicial review of Japanese scientific program, composed of a main structure with a variety of elements. This approach was, of course, inferred from the interpretation of the relevant international convention, but it has an almost generic character and can be used in climate cases where scientific methodology is involved in a legal dispute. It can be characterized as legal technology because the review is not founded on big principles or values, but focus on the reasonableness of the methodology of science and research. The basic structure of the court methodology was the standard of review, which includes, according to the ICJ, 11 elements. First, the distinction between scientific research, and second, the purpose of scientific research. Third, the principle of reasonableness that accesses for the design, and 5, the implementation of scientific program in relation to 6, achieving the program's state research objectives. Furthermore, the standard review enables the ICJ to integrate and resolve 7, the polarization of scientific discourse in the system of law through the use of criteria of 8, peer review, 9, internationalization, 10, animal welfare, and 11, the element of due regard to the non-binding resolution of international convention system. The standard of review developed by the court, by ICJ, was impressive in its ambition, and the task of the ICJ was Herculean, to use a Greek word. Among the 11 elements described above, the principle of reasonableness is, in my view, the most interesting for our today's discussion. Reasonableness is a principle of international law used for assessing factual situations, clarifying legal rules, granting flexibility to law, and enabling the consideration of all circumstances. The ICJ used the reasonableness of the program for the achievement of its objectives as proposed by Australia, instead of the principle of proportionality proposed by New Zealand, which had intervened to the proceedings in The Hague. The ICJ developed the legal technological instrument of standard of review that enabled it to exercise its authority over the design and implementation of scientific research through the principle of reasonableness. The standard of review is the most important element of the judgment and can be characterized as a legal technological device facilitating the exercise of judicial authority over the system of science. By putting this principle of the design and implementation of research at the core of the judgment, the ICJ could rule on scientific disputes within a polarized political and scientific environment. The ICJ was able to take control of the scientific controversy by introducing the standard of review. This standard is an impressive doctrinal construction through which the court, the ICJ, could exercise review over the methodology of Japanese program and over other scientific programs or scientific grant designs. Domestic courts have also developed standards linked to science directly or indirectly, including climate change issues such as the rights of future generations, in the 2021 order of the Federal Constitutional Court on Climate Change, or the major questions doctrine on the limits of the administrative state and prevention of mass unemployment in all industries by the implementation of climate policies, in the 2022 very interesting judgment of U.S. Supreme Court in the case West Virginia versus API. Scientific recommendations and guidelines relevant to climate change should be implemented in accordance with the principle of separation of powers and proportionality that considers also the social cost and the rights of persons and social groups negatively affected by them. The ICJ did not consider the social cost of its approach in the Wheeling case and its impact on fishing communities, nor did it rule on the necessity of a democratic organization of the scientific system as a guarantee of its methodological integrity. Perhaps such issues were beyond the poor review and capacity of a single judgment, but they should be considered in future cases decided by the national or domestic court and tribunals. The standard review is about the methodology of science and seeks to ensure the integrity of research program and the accountability of researchers under the rule of law. Scientific authority must be found on a meaningful methodological basis, and the respective activities should be conducted according to the law. The democratic organization of the scientific system and the equitable representation of all strands of opinion in science governments and in peer review procedures, including of minority or dissenting science, is a prerequisite for the robustness and openness of scientific knowledge. A main question on science is about the role of experts and peer review in the system's governance. In the Wheeling case, the participation of experts was decisive for the outcome. The court took account of their testimony and critically assessed their positions, even though at the end it followed the position of the mainstream opinion in the Wheeling science. The courts are well advised to use legal standards and common sense to make their own assessment of the scientific methods and conclusions, and not to rely uncritically on experts. In the recent DR Congo versus Uganda case, the ICJ criticized the report of the experts it had itself appointed for their methodological shortcomings, even against the experts' 95% confidence. The national courts and tribunals cannot uncritically adopt scientific findings and methods into the sphere of law, but have to perform the translation, another word of our title of our today's symposium, into the vocabulary of the legal system. Power in science is also located in peer review and in the editorial decisions, which is the eighth basic element in standard review developed by ICJ in Wheeling case. The authority to decide on the author's methodology and conclusions is an essential element of the scientific discourse, but it can also be measured by political or other reasons. Peer review bodies should be democratically composed, and diversity of schools or of thoughts and opinions should be represented. Within a democratized and pluralist constitution of science, peer reviews are credible if they include representatives of minority opinions in science. The heated exchanges during the proceedings in the Wheeling case and Norwegian professor's Wall statement, Professor Wall, a Norwegian, if I pronounce well his Norwegian name, was an expert on behalf of Japan, indicate the need for further safeguards for the freedom of research. Similar need had been indicated by the Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression in UN in his report on academic freedom of 2020. Despite the unique feature of the dispute between Australia and Japan, the primacy of science in the judgment was both the result of the legal basis chosen by the applicant and of the increasing significance of science in policy making. The ICJ could have chosen another path, but decided to engage with the difficult option of discussing research in depth. This was not an accidental jurisprudential moment. The political and economic consequences of science raise the question of how law can respond to it. The pandemic showed how science may require and justify restrictions of individual freedoms on an unprecedented scale, and policies on climate change demonstrate the depth of the requested transformation of the routines and patterns of all social systems. If science rules, science should also be subject to political oversight and judicial review and be exposed to open democratic debates. May now come to my final remarks. The reasonableness of design and implementation confirms the ICJ authority to concentrate on the potentially problematic aspect of research programs and request scientists to explain themselves. Indeed, deficient or ideologically prejudiced research may have incalculable consequences on fundamental rights or on social cohesion. Ideological projects or pseudoscience can deceive the public and disable decision makers who cannot withstand public pressures. The standard of review has the virtue of bringing the international legal system into the arena of contention with science and authorize judges to request scientists to explain their methods and approaches. This is a reasonable distribution of power between the two systems in an era of increasing domination of science and technology. The judgment will then translate the scientific conclusion into the language of principles, rights, obligation, and balancing under the law. The big question behind the standard of review that I propose is how to fit the scientific system into the legal system. The two systems remain separate and have different codes and languages. When their rationalities collide, the courts have to find a way to resolve the collision, but there are no meta rules on how to do this. Collisions between democracy and science will create hard cases for the international and domestic courts and tribunals. Here is the willing case fine paradox. The ICJ adopted a digital, if I can say, judgment without big principles, following the expectation style of science and economy in order to exercise its own normative authority upon them. The ICJ developed the standard of review that constitutes a rebuke to the idea of stable normative expectation, but focus on the modalities of research, confirms the autonomy of the system of science, and can prevent the risk of instrumentalization. Political influence can never be excluded, but the clause of purpose of scientific research, if used wisely, can protect science from the manipulation of its code by other systems. The willing judgment has marked a point in which the ICJ showed its ambition, of course, to get involved in the governance of social systems and legally evaluate the merits of scientific research. The national courts and tribunals should exercise judicial review over science under the standard of review, but not necessarily under its variety of strict scrutiny. Some signals given by the ICJ in this judgment offer an opportunity for systemic self-reflection. In this sense, the standard of review constituted a radical critic to a program of research whose social utility was more than questionable. The ICJ judgment contribute within the narrow limits of international law to the rationalization of the digital society. The authority of the ICJ is systemic in the sense that it should consider the fundamental purpose of the UN, United Nations, which is the preservation of international peace and security, and fine-tune the operation of social systems by managing their rationality collisions as far as possible. The ICJ authority does not depend on whether it advances specific outcomes, popular or not, or whether it aligns itself occasionally with progressive or conservative political and legal philosophies, but on whether it can contribute with its limited capacities to the maintenance of global societal pluralism. In general, the potential engagement of international courts and tribunals with climate science which is deeply involved in polarized political discourse, will be challenging, but the international judges should, given the opportunity, apply the standard of review and try figure out what belongs to science and what is political decision and discretion. Thank you.
We have about 2 minutes left in this session, so I would take 1 or maybe 2 short questions if we have any in the room, and otherwise you will have time during the Q&A also to ask more questions. To whom may I give the floor? All right. As I said, you still have more opportunities during the Q&A. If there are no questions in the room right now, I might have a short question of my own. As you were speaking, I was thinking a lot about the importance of academic freedom and of disagreement in producing also legal knowledge. So we need disagreement. We need different opinions. And I'm always a bit worried when it's a matter of maybe constitutionalizing science in a way that maybe eradicates some opinions, things like that. But so, how does academic freedom enter into your perspective on how scientific knowledge and also legal knowledge is produced?
Yes, my approach is just the same. I think with you. I mean that the organization of the science, in order to be of the science and of the academic research, in order to be credible and in order to contribute to the work of international courts and tribunals, should be organized in the sense that there are no exclusion of minority science perspective and approach. Then, as the UN rapporteur noticed in his report, there are many episodes, there are many accidents where this minority scientific opinion is not protected. And there are also some cases also before our court where applicants claim that they are a minority or they have a singular, very separate and very, let's say, marginalized opinion. They are not protected by the state authorities in the sense of the academic freedom. Then my view is the same with them. Is not to ask from the states to involve to academic freedom, but just to guarantee the minimum protection of minority scientists.